Personal counter summary concerning the memorandum of points and authorities supporting the vexatious litigant motion. Briar attorney out of Brightwork Law, license number 33215. Green Thumb attorney. The document summarizes my account of the facts and contents that are materially was misstated, distorted, or omitted in the memorandum of points and authorities filed by attorney Briar in support of a vexatious litigant mode designation, joined by trustee Chabad, Rabbi of Berkeley, 46 years, Yehuda Ferris, and his counsel, 65-year-old attorney William Rogers, license number 154219 out of Petaluma, Shyster Incorporated. It is intended as a plain language background summary for my own records and for review by potential counsel or oversight bodies. It is not a court filing. So background: my brother's illness, care, and circumstances. My only brother was diagnosed in 2014 with advanced liver cancer and repeatedly given a prognosis of approximately 6 months to live. This prognosis was reiterated over the next years as he underwent intensive treatment, including periods of national liver transplant list. He ultimately died in 2020 after multiple hospitalizations for hepatic encephalopathy, also known as liver cancer, liver coma, and repeated complications. From 2014 onward, I assumed the role of caregiver, patient advocate, and coordinator of medical care. I worked in healthcare and emergency response and diverted my own career plans to assist him. During much of this period, my brother was effectively homeless, living in his car, garages, or basements while continuing to work for a wealthy real estate owning couple, Chabad Lubavitch, Orthodox Jewish, we're Jewish, Chabad Lubavitch, Chabad of the East Bay, Yehuda Ferris and Miriam Ferris, who have lived in a $4 million mansion by the Claremont Hotel since, get this, 1983, and own about $40 million in inherited real estate. Yep, ask anyone. While continuing to work for them, this wealthy real estate owning couple, my brother still remained homeless, and when he died, they became trustee and fiduciaries, very suspiciously. Despite owning extensive... Bear with me, God's sakes. Despite owning extensive property and living in multi-million-dollar residence, they never offered my brother housing while he was undergoing cancer treatment, family estrangement, and abandonment. My brother's adult Catholic Filipino daughters, who never converted to Judaism, and their mother wasn't Jewish, the other owner of the house, Nancy Salgado, the daughter ceased contact with him as soon as he got diagnosed and did not communicate with him prior to his death. They ignored outreach from treating physicians at UCSF and did not participate in his care. Their absence during his terminal illness was a central emotional and factual reality of his final years. The context is either omitted or reframed in the memorandum by Attorney Horn in a way that portrays my later actions and statements as harassment rather than concern arising from abandonment during terminal illness. My presence in the home in COVID-era proceedings. In February of 2019, my brother suffered severe hepatic encephalopathy and nearly died. He regained possession of his jointly owned home and invited me to move in and assist with care. I lived there continuously from that point onward. During the COVID pandemic, eviction moratoria were in effect. Nevertheless, the co-owner, my brother's ex-girlfriend, sought a restraining order and removal. I retained counsel and prevailed, with the court explicitly noting that eviction during the pandemic was improper. Plus, I'm a beneficiary in the trust. It gives me 25% of the property. Hello. At that time, attorney William J.Rogers, license number 154219 from Shyster Incorporated law firm, who had drafted the trust instruments and represents the trustee to this day, contacted me repeatedly, encouraging me to remain in the house as leverage against co-owner. He initially represented to the probate court that the trust did not want me removed and sought guidance to avoid favoring some beneficiaries over the other. Reversal of position and escalation against me. Without any change in the law or fact, Rogers later reversed position and amended filings to portray me as a squatter, a freeloader, mentally ill, and homeless. He sought permission to surcharge my beneficial interest for eviction costs, directly contradicting his earlier representations. In May of 2022, I received a threatening letter from Rogers that unless I vacated the home and accepted an unspecified offer, neither I nor my sisters would ever receive our inheritance. We haven't, and it's now 6 years. Trust transfers without court permission. After I filed a trust contest, the trustee and Mr. Rogers transferred the trust interest in the property, approximately one half of a $2 million asset, to the daughters for $82,000. That's specifically against the trust because he was mad they didn't see him. Asking for the transfer as no consideration without prior court approval. This occurred despite trust language limiting the daughter's interest. I later discovered $70,000 in cashier's checks issued to my brother shortly before his death, discarded in his home in a hiding place. I turned the checks themselves over to the trustee. Those funds were later cited as justification for non-payment to the beneficiaries, despite the fact the funds were never distributed as requested. Despite trust provisions requiring payment to my sisters and I, $30,000 each, no payments were made, no interest occurred, no liens were recorded, as per the trust, both trusts, to secure our interest. Meanwhile, substantial attorney's fees were paid, $57,000 at last. That was about 6 months ago. It's probably $100,000 now. And trust-related funds were later alleged to retire unrelated property obligations connected to the trustee. Yeah, he finished buying his empty synagogue that nobody ever attends as soon as he got the money from the trust. We'll let the IRS deal with that. The memorandum characterizes this outcome as a consequence of my litigation conduct. Yeah, right. Admitting that the trust's primary asset had already been transferred for a fraction of its value before I initiated suit. The memorandum contains a materially false assertion that I testified to repeatedly contacting a professional licensing board, the daughters are occupational therapists, and being threatened with police involvement because I supposedly called the licensing board and made an ethics complaint that they hadn't seen their father in 6 years before he died. My actual testimony concerned a single attempted contact with the university library employee while trying to locate my brother's estranged daughters during his terminal illness. Transformation of this testimony into allegations of harassment is a fabrication that went unchallenged until recently due to the absence of the transcript in the vexatious litigant record. Inflation and duplication of alleged lawsuits. The memorandum asserts that I filed approximately 30 lawsuits, and the exhibit supports this claim, repeatedly listing the same cases multiple times, including a single case from 1994 listed over 10 times. Only a small number of unique cases fall within the statutory 7-year period for vexatious litigant designation. This duplication materially represented my litigation history and was raised by me at the hearing without meaningful response. False and defamatory accusations. The memorandum includes allegations that I organized a Holocaust remembrance protest. Never occurred. I'm Jewish. Filed lawsuits because I was denied food, am indignant, mentally ill, and delusional about property ownership. These statements are either wholly false or grossly distort the underlying facts. For example, a cited lawsuit involved a near physical assault on synagogue property by an intoxicated employee, not a demand for food or charity. Context omitted from the memorandum. Throughout the memorandum, my actions are stripped of context. Years of caregiving advocacy, pandemic-era legal constraints, contrary positions taken by fiduciaries, transfers of trust property without court approval, financial self-interest of fiduciaries and counsel. The result is a narrative that portrays me as irrational and abusive while omitting the sequence of fiduciary actions that precipitated the litigation. In summary, this summary exists to preserve an accurate record of my experience to counterbalance the memorandum that relies heavily on mischaracterization, duplication, and omission. It is not intended in advocacy, but a particular reference for those referring the case without prior exposure. Anyone interested in fighting a horrible financial abuse of the elderly case, please contact this email. I don't want a like. I don't care about likes.